died after the commencement of this medical malpractice action, and no substitution was made. The court rendered a conditional order dated October 6, 2000, directing substitution within 30 days of service of the copy of the order with notice of entry. The court warned that in the event the order was not complied with, the complaint may be dismissed. After plaintiff's personal representative failed to timely substitute and amend the caption, defendants separately moved and cross-moved for an order dismissing the complaint. Plaintiff's counsel opposed the motions and cross-moved for an order directing substitution. The court dismissed the complaint pursuant to CPLR 1021. The motion court improvidently exercised its discretion in granting defendants' respective motions to dismiss the complaint and denying plaintiff's cross-motion for substitution. A party's death divests a court of jurisdiction to conduct proceedings in an action until a proper substitution has been made pursuant to CPLR 1015A. When a timely substitution is not made, a court may not order dismissal without first ordering the persons interested in the decedent's estate to show cause why the action should not be dismissed. Furthermore, defendants' bare allegations of prejudice are insufficient to defeat a motion for substitution, especially where, as here, the case is likely to turn mainly on medical records rather than witnesses' memories. Moreover, reversal of the order dismissing the action is in accord with the strong public policy of the state that in the absence of prejudice, a matter should be disposed of on its merits. We have considered and rejected the balance of defendants' contentions. Judgment, Supreme Court, New York County, entered April 27, 2001, which, upon a jury verdict, awarded plaintiff Joseph Strike $100,000 for past pain and suffering and $300,000 for future pain and suffering, structured pursuant to CPLR Article 50B, unanimously reversed on the facts, without costs, and the matter remanded for a new trial unless plaintiff stipulates within 20 days of service of a copy of this order with notice of entry to attribute 25% of the fault for his injuries to his own negligence and to reduce the award of damages accordingly, pursuant to CPLR Article 14A, and to entry of an amended judgment in accordance therewith. Plaintiff sustained a fractured ankle when he slipped while walking down a wet stairway at defendant's subway station. Plaintiff, who contended that the stairs were unreasonably dangerous and when wet because of their worn and chipped condition, was not holding onto the wet stairway's handrail when he fell. The jury unanimously found that plaintiff had descended the stairway in a negligent manner, but found with one dissent that plaintiff's negligence had not been a substantial factor in the causation of the accident. Based on our review of the trial record, we find the verdict to be against the manifest weight of the evidence to the extent it determines that plaintiff's negligence did not play any role in causing that plaintiff's negligence. We therefore reverse the judgment and remand for a new trial unless plaintiff stipulates to entry of an amended judgment as indicated. We have considered defendants' remaining arguments and find them unavailing on this record. CPLR 3126(3) allows a court to sanction a party that refuses to comply with disclosure orders or willfully fails to disclose information that the court concludes should have been disclosed, including the sanction of striking that party's pleadings. While trial courts are accorded wide discretion in fashioning appropriate instructions, Gomez versus New York City Housing Authority, 217, Appellate Division 2nd, 110, 114, 1995, striking the pleading should be restricted to occasions when the failure to comply or disclose is found to be willful, contumacious, or in bad faith. Kaufman versus Triborough Bridge and Tunnel Authority, 295, Appellate Division 2nd, 171, 2002. Such may be illustrated by, but is not limited to, instances when a party deliberately destroys evidence or repeatedly fails to appear for scheduled depositions while also failing to provide responsive answers upon appearing. It is, although present, a matter of fact that the plaintiff complied late. Nevertheless, he has fully complied with outstanding discovery obligations. He has provided a reasonable excuse for his dilatoriness, and there is no indication of bad faith. Plaintiffs are mother and son. The son was shot by an unknown assailant on a street corner near his high school. He claims, without any specific detail, to have felt threatened after unknown persons assaulted friends. His mother and sister allegedly received assurances from a dean at the high school that he would be protected. The motion court properly dismissed plaintiff's claim for violation of a special duty since, inter alia, the record conclusively belies any claim that plaintiff relied to his detriment on any assurances of protection against given by defendants. That is a crazy case. The dean says that, oh, well, don't worry about your son. Well, he's supposed to be out there watching him all the time.